Okay. Distinguished guests, speaker, and fellow participants, good evening to you all. As we are about to commence our session, I kindly request everyone to settle in and ensure your connection is stable. Before we begin, I would like to remind all of the participants the ground rules for today's discussion. First, be punctual. Please join the meeting on time and ensure you remain connected during the session. Second, dress appropriately. Even though it is an online meeting, participants are encouraged to dress appropriately, maintaining a professional appearance throughout the session. Third, minimize distraction. Please find a quiet, well-lit space for the meeting and minimize background noise and distractions. Mute notification on your devices to avoid interruption. 4. Participate actively. We invite an active participation. Please engage in the discussion, contribute your ideas, and listen attentively to others. Should you wish to contribute or pose a question, please utilize a raise hand feature or submit your inquiries through the chat box. Fifth, respect others' speaking time. To maintain order, please refrain from interrupting any speaker. All questions will be addressed during the designated Q&A session. 6. Use neutral language and tone. Please refrain a neutral demeanor in your language and tone and avoid using slang or inappropriate language. 7. Be mindful of camera etiquette. Keep your camera on unless there's a valid reason to turn it off. Maintain proper posture and avoid distracting movements or gestures. Furthermore, to maintain our administrative records, the link for the attendance form will be posted in the chat box shortly. We encourage all participants to complete the form to ensure your presence is officially documented. All right, without any further ado, Om Swastiastu, Assalamualaikum warahmatullahi wabarakatuh, Shalom, Namo Buddhaya, may peace be upon us. I am thrilled to welcome you all to our monthly discussion on global legal affairs. This event is brought to you by the Udayana Research Center for International Law and the Student Community for International Law from the Faculty of Law at Udayana University. I am Luis Awumijaya and I'll be your MC for today's session. Before we proceed, let us extend our deepest gratitude and a warm welcome to our distinguished guests who have graced us with their presence. Dr. Made Susma Prinjanini Devi Salain, SH, MH, LM, as the coordinator of the Bachelor of Law program, Dr. Imade Budi Arsike, SH, LLM, as the head of the International Law Department, and our esteemed facilitator, Professor Igusti Ngurah Parikesit Widya Teja, SH, MHum, LM, PhD. We are here to discuss an issue of international law today with the title Beyond the Text, the Illusion of Non-Binding in the China-Indonesia Joint Statement. This issue questions whether the China-Indonesia Joint Statement is merely diplomatic rhetoric or something more legally meaningful. By exploring the soft law, hard law spectrum, it rethinks where such political documents stand within international law, using the interpretive framework of the Vienna Convention on the Law of Treaties, alongside a Hermetic approach. This research looks beyond the label joint statement to uncover its possible legal force and consequences. To lead us through this inquiry, we are joined by our speaker, Ms. Farah Nadia, a student of the Faculty of Law, Udayana University. Before we move further with today's event, I would like to call upon Dr. Made Susma Prinjanini Devi Salain, SH, MH, LM, as the coordinator of the Bachelor of Law program at Udayana University to give an opening remarks. The time and place is yours.
Thank you, MC. Om Swastiastu, Your Excellency Prof. Palguna, Prof. Parikesit, who are also the initiator and the facilitator for this forum, Bapak Dr. Budi Arsika as the head of International Law Department, Ibu Cok Diah, Farah as the speaker, SCIL President, the committee for this agenda, SCIL members, and other Faculty of Law Udayana University students. It is my honor and pleasure to welcome you to the discussion forum. This forum is co-curricular activity of ACIL that support internationalization of Bachelor of Law at the Faculty of Law Udayana University. Today, we are not here to simply read the law, we are here to challenge it. We are here to look beyond the text, the illusion of non-binding in the China-Indonesia Joint Statement. On the surface, the classification seems clear. In the traditional hierarchy of international law, a joint statement is often categorized as a soft law. It is viewed it is viewed as a political declaration of intent, deliberately crafted to be non-binding to allow for flexibility and diplomacy. When we examine the relationships between two major Asian powers, China and Indonesia, we see that the line between political commitment and legal obligation can become remarkably blurred. These statements, while not ratified treaties, are not issued in a vacuum. They create legitimate expectation, they shape state conduct, they influence the decision of investor, the movement of navies, and the stability of the region. Today in this forum, Farah will explore the document, the joint statement between China and Indonesia. In this occasion, I encourage you to look beyond the text, look at the context, look at the leverage created by shared interests. Thus, this event is officially open. Thank you.
Thank you very much to Ibu Susma for the wonderful remarks. Next, I would
Yeah,
like to invite Dr. Imade Budi Arsike, SHLM, to deliver his opening address. Time and place is yours.
Thank you very much to the MC. So, first of all, I would like to greet Dr. Made Suksma Prijani program of the Faculty of Law Udayana University, which just a few seconds ago officially opened this activity. And also to Professor Gusti Ngurah Parikesit Widiateja, the initiator and the founder of Udayana Research Center for International Law and Policy, the UNCIL, as a prestigious research group at our law school, who will also serve as the moderator today. And here we also, I think we can identify that there are several professors and lecturers of International Law Department. We have the His Excellency, former judges, former justice at the Indonesian Constitutional Court, Professor Idewagede Palguna, and also Ibu Dr. Chok Istri, Dia, and other colleagues here. And also Miss Ana Agung Safita Duty Anaya, the President of Student Committee for International Law and her Executive Board. Miss Farah Nadia, the Speaker, which will deliver the topic of the non-binding of the PRC, the China-Indonesia. It is my honor to represent the International Law Department today. Yes, I'm so happy because we organize again the International Law Today, the monthly discussions on global legal affairs. I'd like to inform you that it is a program that is jointly organized by International Law Department and the Student Community for International Law. And since last year, the Udayana Research Center for International Law and Policy, the UNCIL, thank you very much to Professor Parikesit Widiateja, because the UNCIL, during the time where the Professor Parikesit holds the chair as the International Law Department, initiated this program. And this program regularly presented the most talented students who conducted research on international law as part of his or her bachelor thesis to disseminate their knowledge and research results. Therefore, I think this event can show that international department and student community for international law, as well as the students who interested in international law at our law school, always update with the ongoing issues of international law. Without further ado, allow me to express my thankfulness to all committee which worked very hard to prepare this event. So thank you very much once again to all. So I hope this event can be conducted successfully. Thank you very much, MC.
Thank you very much, Mr. Budi Arsika, for the wonderful remarks as well. At the moment you've all been waiting for, all distinguished participants, I am excited to introduce our speaker, Ms. Farah Nadia, a student of Faculty of Law, Udayana University. Her research presents a compelling inquiry into the soft law, hard law spectrum, challenging the traditional boundaries of diplomatic rhetoric through the lens of the Vienna Convention on the Law of Treaties. Also, to help us navigate our discussion, please welcome our facilitator, Professor Igusti Ngurah Parikesit Widyateja, SH Hum LM PhD. To Professor Parikesit, the time is yours.
Okay, thank you so much. Thank you so much, Luis, as a master of ceremony for the nice opening. And Your Excellency, Ibu Dr. Made Suksma, as a Bachelor of Law Study Coordinator, Bapak Dr. Made Budi Arsika, as a Head of International Law Department, Professor Dr. Idewo Gede Palguna, as a Law Professor in International Law Department, Ibu Dr. Chok Istri Diah Widiantari, as a Lecturer of International Law Department, and other International Law Department lecturers that who are already joined on this special event. I would like to inform you that today is the 5th session of International Law Today. Only discussion on global legal affairs. So, as Pak Budi has mentioned earlier, that this program actually try to capture the potential, the talented students, especially when the students have completed their Bachelor of Law thesis, after completing and passing the process, then we will try to provide a venue for them to express, to broadcast their idea, their notion to the wider audience. So the idea is pretty simple. How we can organize a kind of event in English when the student have complete their final thesis. And the audience, I can say that the audience is a combination between student from Faculty of Law Udayana University. The first is from Faculty of Law Udayana University. I can explain that the participant, the participant on tonight session is a member of international law classes. So we have 13 lecturer of international law department, and I think almost all class on international law will be joined, yeah, because my colleagues from International Law Department eager to announce this event. Also, we have a participant from international contract law classes. Yeah, that's when I'm becoming the lecturer. International law course from Faculty of Social and Political Science. Yeah, they also joined today. We also have student community international law. Yeah, it's not just as organizing committee, but also as a participant as well, because I asked Ms. Naya as the president to also to announce and to invite all the member. Yeah, there there is also a participant from Udayana Mudkot community. Yeah, from CLC, yeah, criminal law community, from ALSA, ALSA, also from international undergraduate program, and yeah, there are also 3 students, yeah, from University of Saint Islam Malaysia who are joining tonight. So in this session, the audience is quite wider than previous one. So hopefully, this yeah, because we have a tagline "Kampus Berdampak" or impactful university. So this program will be a bridging point to reach that vision. Okay, that's for the participant that I can inform and report to all of you. Thank you so much for coming to this event. Yeah, from the participant number, I count around 122 participants have already joined this event. And thank you again for the ACIL to organize this event as well. And I can say another important information that I can share to you, because the event, yeah, is not just, yeah, the event is recorded and then will be uploaded to the YouTube, yeah, because UNCIL or Udayana Research Center for International Law and Policy has already YouTube channel for the last 2 years. So hopefully, yeah, after this one, you can, if you need more further information to recite and to find something relevant and important to your project or research, then you can go back to watch. Yeah, and thank you for Bapak Dr. Made Budi Arsike, because one special measure, yeah, one special measure that can be done tonight is the result of this discussion or the video documentation of this discussion will be registered to the Copyright Bureau of Indonesia. So we will register this as a copyright acknowledgement. Yeah, there will be any certificate of copyright of this video. So that's the one of the special that I can share and inform to all of you tonight. Okay, and now let's move to the speaker of this event tonight. We have Farah Nadia, who will present about beyond the text, the illusion of non-binding in the China-Indonesia Joint Statement. Yeah, I think in the situation when the international law is under siege, or under there is so many controversy because the current conflict, because the weak enforcement, and also the geopolitical tension that happening today. I think this topic is quite relevant, and particularly because yeah this thesis put China as an example of Indonesia international relationship, and making a relationship with quote unquote big countries, is always exciting. We have in the latest one we have agreement. That's an agreement because the title is agreement. We have agreement on trade, reciprocal trade with the US, and that also raised a controversy. And we can then compare how then this joint statement conducted by Indonesia and China compared to the latest relationship or the latest agreement involve Indonesia. And before letting Farah to start their presentation, I would like to inform the curriculum, the curriculum vitae of Farah Nadia. I think Farah is one of the most talented and potential students that Faculty of Law Udayana University have. She is specializing in international law, active participant in student organization, and develop her strong leadership, interpersonal communication, and teamwork skill. Farah has participated in multiple international moot court competition. I can mention like Philip Jessup International Law 2025. I think she went to Washington DC. She also joined the 19th Indonesia National Round of the International Humanitarian Law Moot Court Competition 2024 and grabbed third runner-up. She also joined the international round of the Asia Cup International Law Moot Court Competition. I think it was in Japan. And from her organization, she was the president of UNCIL in 2024. I remember her because when this discussion or the English discussion event was started, I think in 2024, I think Farah was the president of SGIL. I think in the first or the second session of International Law Today, Farah was in charge to be the head of organizing committee at that moment. And she is waiting for her formal graduation, I think in the next April. And while waiting, Farah has joined in one of the reputable law firm in Bali, in House of Legal Expertise. and practicing and applying her legal knowledge. Okay, I think that's all for my brief explanation about the event, about the participant, and about the speaker today. And it's time now for Farah, I think for 15 or 20 minutes to start your presentation. Time and place are yours, Farah.
Thank you so much, Prof. Parikasip. Am I audible?
Yes, you are.
Okay. Before I start, I actually have a technical problem in my at first.
Okay, yeah. Yes, yeah.
Okay. Thank you so much.
Hopefully, the technical problem is not because we talk about China. The more technical problem if we talk about agreement between Indonesia and US maybe. And for information while waiting, because in international law department we will have latest discussion on how Indonesia have involved in international relationship. Yeah. So there is a bachelor thesis, ongoing bachelor thesis that talk about the how Indonesia uh, the Indonesia challenge, yeah, to join in, for example, to join in bridge, yeah. And when I mentioned about Indonesia and America reciprocal trade agreement, then it is a chance for, especially for students who are joining international law specialization, because the topic about the agreement between Indonesia and US has not yet developed and analyzed in Faculty of Law Udayana University. So there is no reason to get stuck to find a good topic for your thesis. Yeah, because in international law we have so many topic, because now international law and international relationship in the broader term, yeah, are undergoing situation where, yeah, everything is bit messed up. And for the participant, for the newcomer on this event, I encourage you to be actively involved on this discussion, because this is the forum for academic forum, purely academic, purely legally based discussion, no need to be afraid, no need to be worried, because we can prove that this is purely academic forum. No one will be prosecuted because of this, because we have also the new Indonesian criminal code and the new Indonesia uh, criminal procedure. So, but again, under the constitution, under the principle of human right. Yeah. Okay, I think Farah has tackled her technical problem, and let's hear what Farah is presenting.
Okay. Am I audible?
Yes, yes, you are.
Thank you so much, Professor Parikesit, Dr. Suksma, Dr. Budi Arsika, His Excellency Professor Igede Dewa Palguna, Dr. Chokorda Istridiah, as well as the student community for international law, and all of the participants that have joined this event today. Hi everyone, my name is Farnadia. I'm a student of the Faculty of Law Dayan University, and in this opportunity, I will share a little research that I did for my Bachelor of Law thesis, which for this event, I titled it Beyond the Text, the Illusion of Non-Binding in the China-Indonesia Joint Statement. Okay, so before we jump into the analysis of my research, I would like to invite you guys to do a little throwback in the year of 2024. So this is quite a controversy in the international relations of Indonesia and China back in the year of 2024. It was all started on November 8th, 2024, where Prabowo Subianto, the president of Indonesia, visits China at the invitation of Xi Jinping, the president of China. So, as usual, both leaders discuss bilateral relations as well as their cooperations. This cooperation has started for a long time. If I'm not mistaken, it's since the year of 2005. And in this meeting, both leaders discuss several issues covering the regional and global issues. A day later, on November 9th, 2024, a joint statement is released. It was signed by both parties, covering several issues, not only a single issue, such as economics, politics, maritime, and etc. However, following the signatory of this joint statement between Indonesia and China, it sparks a controversy, especially in the discourse of international law of the sea, for its maritime issue in the point 9. So before we find out what the experts take on this issue, I would like to present you the actual problem. This is the second paragraph of the point 9 of the joint statement, which I already highlighted a phrase, overlapping claims. That basically this paragraph means that both China and Indonesia is reaching a common understanding for conducting a joint development in areas of overlapping claims and agreed to establish a kind of a committee to conduct a preliminary exploration for the joint development. Okay, if you guys following the issue of the South China Sea conflict, the phrase of overlapping claims might sparks a question in your mind because for a long time since the South China Sea conflict is happening, Indonesia has never been a claimant state, and Indonesia's position is always consistent that the China's claim, which is the 9-dash line, 10-dash line, as well as maybe 11-dash line, is inconsistent with international law, especially the United Nations Conventions on the Law of the Sea. Okay, I compiled 3 experts' take on the issue. The first one is Professor Hikmahanto Juwana, the professor of law in Universitas Indonesia, which said that this joint statement may imply that Indonesia has acknowledged China's unilateral claim over the so-called 10-dash line. The second one is Dr. Evan Laksmana, one of the researchers in CSIS, if I'm not mistaken. He said that the joint statement marks a setback for Indonesia's stance on China's South China Sea claims. And the last one is Dr. Aristio Rizka Darmawan, one of the lecturers in Universitas Indonesia, which said that by this joint statement, Indonesia appears to be the first ASEAN member state to implicitly recognize China's 9-dash line. So the question is, whether this joint statement is really having an impact on Indonesia's position, especially towards the South China Sea, and whether it is potentially having legal consequences towards Indonesia. But to find the answer, I already constructed at least two questions, especially focusing on the study of international law of treaties. The first one is the China-Indonesia Joint Statement truly non-binding? And the second one is, does the China-Indonesia Joint Statement create legal consequences? Okay, we will move to the first question first. In my research, I use legalization theory or concept. This was significantly developed in year of 2000, so it's quite new in international law discourse. Basically, the legalization itself is refers to an element or elements that may or may not contain in an international document. So, if you took an international law of treaty class or treaty classes in the campus, we might be familiar to the classification of international law, which is the soft law and hard law. That those are maybe the traditional one. This legalization concept itself is not viewing the soft law and hard law as a black and white. So it's basically views that the soft law and hard law itself is a spectrum. Why? Because actually this concept is developed due to the phenomenon of countries which using the non-binding agreements like memorandum of understanding, joint statement, or joint press release to solve their conflict instead of an international agreement or international treaty. And by this legalization concept, it viewed that in fact, several international agreements or international treaties which at the prima facie having a binding force is not that having an effective way or effective binding force to solve the problem between the countries. However, several non-binding agreement like MOU or joint statement is proven to be effective in solving a problem between the countries. This legalization concept, as shown in the slide, is having three dimensions. The first one is obligation. It is how the norm is governed in a document, like what state may or may not do, what can we do or what cannot we do. This is the most significant part of legalization. So it has a happy point in counting the legalization later. The second one is delegation. It is how the parties of an international document is delegate. Maybe if further there's a conflict arises from the implementation of this document, whether or not these parties is delegate it to another independent institution, like maybe international court. And the last one is precision. It is refers to how precise a norm or a provision is governed. Like maybe, for example, in an agreement or in a document, both parties agree to conduct a ceasefire for 90 days. That is how precision works. Okay. This is actually the analysis of how legalization looks like in China-Indonesia Joint Statement. For the transparency, we actually use a notion which can be seen in the slide. However, due to the constrained time, I will straightly move to the result of the analysis. So to position China and Indonesia Joint Statement in a spectrum of hard and soft law, I do a comparison study with the European Union and Japan Strategic Partnership Agreement, as well as a joint statement on eel conservation, which was made by Japan, China, Korea, and else. So basically, due to the comparison between these three documents, the China-Indonesia Joint Statement is having a low score of obligation because it is using a hortatory language and it is not govern a provision which is clearly say what Indonesia and China can do, what they cannot do. And for the second dimension, the joint statement of China and Indonesia is not delegating a conflict that may arise between the two nations for the implementation of the joint statement to an independent institution. And the last one, the precision of each sentences in the joint statement of China and Indonesia is quite low because the hortatory language that is used, which is not showing a strong legal commitment between China and Indonesia. And by looking at these findings, it's basically Indonesia and China joint statement itself is having a very low position in a spectrum of hard and soft law. It might be clearly can be seen that Indonesia and China joint statement, as previously discussed and said by Ibu Dr. Suksma, too, it can be positioned as a soft law, which is a non-binding agreement. However, to find whether this joint statement of China and Indonesia is potentially possessed a legal consequences, we need to do a little bit more analysis, especially on the interpretation of this document, particularly in, again, the paragraph 2 of the point 9 of the joint statement of China and Indonesia. So to complement the answer, we would like to move to the second question, whether Indonesia and China joint statement is potentially having legal consequences by two interpretative methods. This research is using two interpretative methods. The first one is on the Vienna Convention on the Law of Treaties in the year of 1969, using the Article 31 and 32, which further complement by hermeneutics approach. Why do I use these two methods? Because basically the joint statement of China and Indonesia is not a treaty. And VCLT framework of interpretation is fundamentally made for an international treaty. So to complement and to strengthen its analysis, I use the hermeneutic approach, which we can see the difference here. I use illustration. If we can see on the VCLT one, it is very systematical and limited to a normative framework of the VCLT itself. We will do firstly looking for the ordinary meanings for the key phrases in the joint statement, and then we will compare it and we will add it into the context in the joint statement itself. On the other hand, the hermeneutics approach, hermeneutics is basically a philosophy, which one of the philosophers here that I quoted a lot is Hans-Georg Gadamer. It is what is the difference between hermeneutics and the interpretation in general. The hermeneutics itself is heavily relied on the understanding rather than a merely exegesis of the interpretation process. So if we can see, the hermeneutics approach is started from the fusion of horizons between the interpreter, which is in this case me as the researcher, as well as the text. So we are going to use the inductive method, and the key difference of this interpretative methods is that in hermeneutics approach we could widen our lens. There's so many factors that we cannot consider in using the VCLT one. So we will move to the back again to the problem. This is the second paragraph of the point 9 of the joint statement between China and Indonesia. I already highlighted three key phrases. The first one is common understanding, joint development, as well as the areas of overlapping claims. As I said before, we will use firstly the general rule of interpretation, which is finding the ordinary meaning of these three key phrases, and we will complement it with the supplementary means. Okay, the first one, before I continue, I would like to give a little heads up that this process of interpretation by the VCLT itself is already conducted considering the context as well as the object and purpose of the joint statement itself. The first one is common understanding. The International Law Commission in the year of 2018 has defined common understanding as the situation where the parties reach a common understanding of a provision. So basically, China and Indonesia in this case have been agreed about the issue, which is it is the joint development between two nations, which further joint development itself in the case of International Court of Justice between Guyana versus Suriname is defined as exploration and exploitation of resources in area with overlapping claims. It is also related to one of the provision of United Nations Convention on the Law of the Sea, precisely in Article 74.3 as well as Article 83.3 with regards to professional arrangement. Basically, the joint development itself is one of the way of countries solving a problem of overlapping claims by conducting a joint development for exploiting and exploration of resources within that areas. However, this mechanism is not the final mechanism. It is only used before the both countries or both parties reach the final agreement of the maritime delimitation. And the next one, overlapping claims. In the case of Romania versus Ukraine in the year of 2009 in the International Court of Justice is reversed to projection of overlapping coastal areas between the parties. So there is a projection maybe from Indonesia and as well as China, which is overlap. Which further we will find out whether there's an overlapping projection between China and Indonesia. The overlapping claims itself is also related to the provision of maritime boundary delimitation in the UNCLOS Article 15, 74.3, as well as 83.3. One of the things that I would like to emphasize here is that this reading of the ordinary meaning of joint development, especially for joint development as well as overlapping claims itself, is very related to a concept in the international law of the sea. Because if we look back at the decision of Permanent Court of Arbitration back in the year of 2016, Philippines have brought this case, the South China Sea conflict between Philippines and the China, into the PCA. And in that case, Philippines itself consistently saying that there is no overlapping entitlements can exist because the only legal entitlements or entitlement that is aligned with international law is the Philippines. Okay, for the next one, I would like to point out the map of the South China Sea. I would like us to look at the left one with no 9-dash line. If we can see, geographically, we cannot straightly pinpoint the overlapping area between China and Indonesia because we have a quite big way to pinpoint the overlapping area. And however, if we look at the 9-dash line claim by China itself, it is covering almost entire South China Sea areas, which further, if we can see, this is the Natuna Island. It is Indonesia's, and geographically and factually, it is overlapped with the China. However, I would like to remind us that Indonesia's previously have a long-standing stance that Indonesia is not recognizing the China 9-dash line claim, as well as stating that it is not aligned with international law. So the next one, we will complement the analysis with another tool, which is using the hermeneutical approach. As I stated previously, hermeneutics itself is a process of understanding, which in this case is using a hermeneutic circle. There are 5 stages of interpretation. The first one is immersion, followed by understanding and abstraction. The fourth one is synthesis, and the last one is final understanding of the interpretation process. So basically, I divided this into 5 stages. The first one is the initial prejudice. The first reading of the joint statement is the finding is that the language employed is political, diplomatic in nature, and reflects the sensitivity surrounding the South China Sea dispute. For example, the phrases of overlapping claims as well as joint development. The second one is the second stage, understanding, the initial textual reading, which the joint statement between China and Indonesia itself demonstrate a low level of legal commitment. However, there is an ambiguous phrasing which creates an interpretive tension, which is the overlapping claims as well as joint development phrases. And the next one, in the abstraction phase, the key findings shows that the terms overlapping claims and joint development are interpreted within the broader discourse of international law of the sea. For example, overlapping claims itself by the discourse of international law of the sea is reverse or function as a categorical sign, which is there's a projection between two parties in the area which is overlap. And the joint development itself is actually China has already conducted an approach which related to this research from the year of 2017 in the South China Sea. China is using setting aside dispute and pursuing joint development approach for the South China Sea conflict. It is analyzed by several experts in international law too, that it is maybe impossible for China for using a military force in solving the problem of South China Sea. So this is very common, which the joint development approach itself have already conducted as well with Vietnam as well as Philippines. However, Philippines and Vietnam itself, they both cancel the joint development plan with the China itself due to their internal decision. So the cumulative analysis of overlapping claims as well as joint development phrases itself is delivering us into the fourth stage, which is synthesis, which is the integration and the validity check, which we find that the terminology is not neutral. Rather, it presupposes the existence of the 9-dash line claim. Why? Because the first one is the use of overlapping claims phrase is not equals to the situation of refusing the existence of another claim of the parties. And factually and geographically, as we said, as we seen before, is the most possible overlapping claims between China and Indonesia is the projection of 9-dash line and the areas of North Natuna Island. So it is very logically and geographically, it is related to the recognition of Indonesia, at least for the existence of the 9-dash line claim. And the second one, the joint development itself, as we have already discussed before, in the realm of international law of the sea, is commonly used when there are two countries which having an overlapping claims problem. Okay, for the next one, I would like to pinpoint the international affairs policy of Indonesia, which is bebas aktif, prinsip bebas aktif, which is it is related to how Indonesia, in this case, President Prabowo is trying to find a stability between China and Indonesia, because if we trace back, the only emerging problem between Indonesia and China is the South China Sea conflict, as well as President Prabowo itself for the note as well. is very oriented to the development of economic of Indonesia. And as if we trace back to the year of 2024, after the inauguration of President Prabowo, this meeting with the China itself is the first meeting of Prabowo, which is followed by the meeting with the President of United States, as well as several international meetings. After this state visit or the international visits of Prabowo Subianto, Indonesia is gained several investment commitment, which the big one is from the China. And if we may trace back to the post-signatory of Joint Statement of China and Indonesia, both countries, Indonesia and China, is releasing press conference, which the Foreign Affairs of Ministry of Indonesia is saying that there is no recognition of nine dash line of the China, and Indonesia is still consistent in its position that the nine dash line itself is not aligned with international law. However, again, after the visit to the China, Indonesia visited the United States of America and signed another joint statement. In that joint statement, there is an issue which related to the South China Sea, which both parties, the U.S. and Indonesia itself, is renoting the Permanent Court of Arbitration decision in the year of 2016 between Philippines and China, that is the nine dash line is not aligned with international law. So, by this hermeneutic analysis, although there is a clarification from the Foreign Ministry of Indonesia, as well as the fact that Indonesia and the US having a note on the South China Sea issue is not negating the fact that this joint statement, through its logically analysis and also as well as the interpretative analysis, is implicitly recognizing the existence of the nine dash line or China's claim on the South China Sea. So we would like to move to the last part, which is the conclusion. I would like to pinpoint that the first one is the China-Indonesia Joint Statement is positioned as a non-binding agreement or soft law within the spectrum of hard and soft law. And the second one, it carries indirect implications, especially in the realm of diplomatic and politic, as well as interpretative, to the exclusivity of Indonesia's maritime rights, specifically in the North Natuna area. So I guess that's it for my presentation. Looking forward for any further insights or suggestions. I will give back the floor to Professor Parekasit.
Okay, thank you so much, Farah. To be frank, your presentation so superb, exceptional, and inspiring. Yeah, I can say that I myself enjoy your presentation, and one information that I can inform to all of you, yeah, actually the one who supervise Farah, yeah, is Prof. Palguna along with Ibu Dr. Chokdia. I myself not involved even as an examiner of her bachelor thesis, right? But yeah, this is actually my first time seeing her presentation and talking about maritime, about law of the sea. Is a bit beyond my expertise, but understanding and watching her presentation, I got also many valuable information, and some of them are relatively new. Yeah, I can say that for the visual one, the how Farah can present like the images, like the diagram, the scheme, the tabel involved in this PPT, I think is so great. So everyone, and especially who are not yet involved or research in international law, can be understand about our presentation. Again, thank you so much, Farah. And I don't think that I should repeat should repeat her presentation or give a comment or brief explanation, because I think everything is clean. The problem, the legal problem is clear. The method is exceptional because yeah, Farah mentioned about hermeneutic, something that exceed. I think that I can say this is exceed the the capacity of bachelor of law student. Yeah, yeah. I think you suppose this method or this topic, and then the quality of the the topic, yeah, should be at least in the master of law degree. So uh and the topic also is quite important, quite challenging for Indonesia, because yeah, when we say that Indonesia and China, oh, this is only a soft law, only a soft development and nothing to worry about. And then after Farah explained about the method of interpretation, yeah, hermeneutic, then we are aware about the potential implication, the hidden implication. Farah mentioned about the two phrases, joint development and overlapping claims. That can be a problem if it is not well prepared and well anticipated by the important stakeholder in Indonesia. Yeah, because this has become yeah, it's very sensitive. The issue of maritime, especially in the South China Sea, which is now changed into yeah, yeah, South China Sea now becoming North Natuna Sea, yeah, and becoming a sensitive issue for the Indonesian sovereignty. And again, this topic, and along with the presentation, is perfect for the beginner to understand about the Indonesia position in the international relationship. Okay, before opening the this is should be the most interesting one, because I will involve all the audience involved in this event to raise, to ask, to comment, even to criticize, yeah, or to give some another evidence if you don't agree with what Farah has mentioned. But before I'm opening the session, I would like to invite, yeah. So because the supervisor, the dosen pembimbing, yeah, I have also give a respect to Prof. Palguna and Ibu Dr. Cok Dia, yeah, who perfectly guide and supervise Farah to create this amazing job. So for the first opportunity, I would like to invite Prof. Palguna to give some thoughts maybe about Farah presentation and topic.
Okay, thank you, Professor Parikesit. And again, I would like to, firstly, I would like to appreciate your effort, your initiative to build this event. And I think as far as the liberty of international law is concerned, this is an important venue for all the students of especially who concentrate their study in international law to join the occasions, because it is practically a venue not only to express the concern of a student into an international issue, but it's also to encourage other students to try to express their will, their insight, or their interest in international issues. Frankly speaking, as one of the para supervisor, of course, I'm very proud of Farah, not only because of her achievement in her bachelor's thesis, and also the actual and important issue she take into the spotlight with her bachelor thesis. But frankly speaking, I can say that I was almost done nothing in guiding Farah to delve into the issue she studied, she analyzes according to South China Sea issues. I only give maybe a kind of maybe a kind of a way of analysis during Farah consulted me of her first draft of her proposal of her bachelor degree scripsi or thesis. The rest is Farah herself efforts. And I must say that I'm very grateful, not only for her achievement in analyzing the issue, but also for her what is it? Her great intention she's given to finalize or to complete this undergraduate thesis. So again, I would like to express my deep appreciation, thankfulness, and also my pride to Farah. Thank you, Professor Pariksit.
Okay, thank you so much, Prof. Palguna, for your valuable comments and also insight. And yes, watching and reading your presentation, yeah, is quite interesting, yeah, because as I mentioned earlier, we talk about something that very happening amid the condition of international relation, including international law, is in the uncertain. Yeah. Yeah. Some international law scholar like me, like my colleagues from international law department, yeah, sometimes express like a jokes, yeah. Do we need to promote and teach international law where what has been stated, what has been written is quite different than what is actually happening. the gap between yeah, we call it Dasolon and Dasin, is so wide in terms of international law. And for the next, yeah, because we also have, yeah, the second supervisor, who is Ibu Dr. Istridia, who is also who is going to be the next facilitator for the next event tomorrow. I would like to invite her to give like a brief comment for Farah works. Okay, Ibu Dr. Cho.
Okay, thank you very much, Professor Parikesit, uh, and for all professor and colleagues from International Law Department and all the participants, and of course, Farah. Thank you very much for a great presentation. And I only add little from what Prof. Palguna said, previously, because he already say everything. And like he said that for me, how to be a Farah supervisor is kind of easy job because Farah was so excellent, and she did all of her thesis, I think, by herself. My contribution maybe only it's not only 1% maybe. I only help her to format it, uh, how to finishing, and only terrorism becomes when will you finish? When will you finish? So thank God, Farah already finished with great, and she also the topic that she brought is was particularly because it's about the hermeneutic. But thank you very much because it's also important for international law, maybe uh, especially international law today, because we already know what's going on in Indonesia, and also what's going on in the international politics, international relationship, and how we manage our position in internationally. And I hope now and future will be better, and there is no war. Because I hope there is no war, and I hope we can keep. I mean, like honestly, I feel confused when we have to share knowledge with the students about international law, because we know what happened today. But I I encourage the students that uh, it's okay. We can keep study about international law. So I hope what Farah did today will will give encouragement to the students that join today events, and will give encouragement also to take maybe their last thesis or journal about international law, because we will get many topics for international law. I guess that's all. I hope all the participants today will actively giving comments or asking about presentations, about Farah presentations. And thank you very much for Prof. Parikesit to facilitating and to initiating this event. And also thank you for Prof. Palguna, for Pak Budi, and also Ibu Suksma. That's it for me. Good night. Thank you. I give back to Prof. Parikesit.
Thank you so much, Ibu Dr. Chok Dia, for your comment and also insight. And now, without further ado, I would like to invite all participants who are joining now to briefly, ask the question to Farah. Make a very hard question to her. Make her unable to answer the question. I challenge you. Yeah. Uh, okay, is there any who would like to be the first? I would like to invite the participants. Yeah, all the participants. Yeah, even for the first year student, you are also welcome. Yeah, because we are equal here. Yeah, we are all learner. Yeah, don't feel under pressure or feel a bit worry about making a mistake. Yeah. If a student make a mistake, that's very fine. Yeah. But if the diplomat make a mistake, that's going to be a problem. Okay, guys, who would like to raise a questions? This is a hot topic. Yeah, because when we negotiate with big countries, usually big countries bring a big interest, big national interest. And in her thesis, I think Farah also mentioned about one of the China national interests. Yeah, usually it's called BRI, Belt and Road Initiative, and I think that's the 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 reason. I think in my personal opinion, one of the reason why China want to hiddenly escalate or expand its territory. Yeah, because it's because they have very big national interest on that. Okay, who would like to join?
Hello? Yes?
Yeah.
Hello?
Yes.
Yes. Hi.
Good evening.
Hi. Good evening, everyone. My name is Raji Ilyas, which is I'm from University Saint Islam Malaysia.
Oh, yes, yeah. Oh,
Yeah, Pak
yes.
Sigit.
Thank you. How
I have,
is Kuala Lumpur?
yeah, he's good.
Are you in Kuala Lumpur or Nilai?
Yeah, Kuala Lumpur.
Oh, Kuala Lumpur. Okay.
Yeah. I just have a simple question for Farah. Okay. So I think even so the question is even if a joint statement is labeled as a non-binding, can it still influence state behavior or contribute to customary international law over time?
Yes. Serius.
Yeah.
Apa?
Yang pencet itu Bang. Raja Ilyas kan?
Yes.
Yes, kata dia.
Oh, yang
Okay.
Is it okay?
Yes. Yeah. Have you finished?
Yeah.
Okay. Okay. Farah, may answer directly.
Okay. Thank you, Raji, as well as Prof. Parikesit. Am I still audible?
Yes. Yes, you
Okay.
are.
Okay. Thank you so much for the question, Raja. The first question is whether the joint statement itself can influence the state behavior. I guess a short answer is yes, because as I have mentioned earlier, one of maybe why this topic, well, for me, has become interesting because there is a phenomenon of the countries using a non-binding agreement rather than maybe making an international agreement, which is the hard law itself. Because if I may take this discussion to a joint statement of conservation, which is made by Japan, South Korea, Taipei, and China. It is one of a clear example, I guess, of how a non-binding agreement itself is succeeded to solve a problem more concretely rather than a hard law one. And I guess due to the high raising of the use of non-binding agreement, it could, okay, connecting it to the second question, it could maybe building or forming a customary of international law because I think the international law commission itself is currently in their process of studying the topic of non-binding agreements. It is started in, if I'm not mistaken, in the year of 2022, and until now they are still conducting a study of this non-binding agreement and how it is effectively giving an effect to the international relations between the countries. I hope it answered the question.
Okay, thank you, Farah. Do you have any follow-up comment or question, Ilyas?
No, Pak Sigit. I satisfied with the answer. Yeah. Do you have any comment, Pak Sigit?
Oh, oh no. Just I would like to say thank you for your present along with Nabil and also Adam.
Happy.
Yeah.
Yeah.
And
Yeah.
just for information, because Ilyas and other two students from Malaysia have visited Faculty of Law Udayana University and over, yeah. So we have initiate ASEAN classroom law program, yeah, and hopefully Faculty of Law Udayana will be involved in that program in the future year. Yeah. Okay, thanks again for your question, Ilyas, and have a good one in KL. And there is a question from Nadine. Yeah.
Hello, am I audible?
Yeah.
Thank you for giving me the floor. First of all, also kudos to Farah because it's an interesting topic. I would like to ask regarding the fact I'm really interested in the political aspect of this discourse. What would you say? Do you see like if the leadership in a country, like say China, the leadership change, would it also mean that they have a different, political vision in regards to, because like you said, like this is like a non-binding statement. It's a soft law. You cannot impose obligation for parties to follow along because you don't have any legal basis for that. So my question is that would you say that it is effective in imposing responsibilities for state to follow along their agreed statement, or does it mean like if leadership changes, then everything falls back to square one? Thank you.
Okay, thank you, Nadine, for the great. I think the question is pretty. For me, it's pretty hard, but I don't know because Farah has already write and do a research for this issue. I would like to invite Farah to answer the questions.
Thank you so much to Kak Nadine. Kak Nadine is one of my senior in back in international humanitarian law moot court competition, my first competition in the year of 2022. So thank you, Kak Nadine. I guess, well, this is quite a hard question for me. However, I will try to answer it. In my opinion, this joint statement itself is maybe quite hard to have a real effect to both nations, except maybe one of the party um, maybe bringing this issue to the international court for clarification of maybe the interpretation of this joint statement, because there is a case in the International Court of Justice which is also interpreting a non-binding agreement in a form of memorandum of understanding, and the decision itself is stated that this MOU has a legal effect on the parties. So I guess if only maybe Indonesia or China is there's still a possibility of both parties for bringing this issue to the international court. Uh, uh, and the second one, regarding the changing of the leaders of these countries, I actually need more research whether there's jurisprudence of the past international document which is signed in the past leadership of a nation. However, I think it still can be brought to the maybe if we talk about the judicial process, I think it still can be brought to the process of the adjudication, because uh, maybe not as a main part of analysis. However, it could be contributing to the supplementary maybe as an evidence or as supplementary tools of interpretation. I guess that's all for me.
Okay, thank you so much for your answer, Farah. Before I give back to Nadine, yeah, because I know who you are, I know where are you now, but not all the participants know you. Please introduce yourself and where are you now, Nadine?
Oh my God. I'm sorry for the noise because I'm waiting for my tram. Hello, everybody. I am alumni of the year 2020. Yes, I think. I am now pursuing my master's, University of Zurich. So now I'm staying in Zurich, Switzerland. And thanks to Prof. Parikesit, actually, I can do my thesis quite well. And yeah, now I'm very grateful to be here. And also Pak Budi as one of my not advisor but examiners. So now I still have 1 year to do international law here in Zurich. And I'm studying on the program International and Comparative Law. So yeah,
Oh,
nice to meet you all.
okay, thank you, Nadine, for the brief introduction. And don't be alone here. Please invite Farah and other law students from Udayana also to go to Zurich, Geneva, or somewhere else in Switzerland, because I think Switzerland, I never been there, but I hear that that country is beautiful and safe because yeah, Switzerland is a neutral, neutral in terms of international law. It is considered as neutral country. Yeah, yeah, as long as I know. Okay, have a good one in Zurich, and thank you so much for attending this event. Okay, do you have any comment, Farah? Or that's enough?
I guess that's enough, Professor.
Okay. Okay, I would like to invite another one because we still, yeah, have, I think, 20 minutes, yeah, 20 minutes for the discussion. And I will invite again all participants, yeah, while maybe watching China movie or China drama, because don't forget, I already mentioned, or I already uh, sent a full text of joint statement, in the chat room, so you guys can access. And yeah, one of the content of the issue also raised from the joint statement is not just about the maritime, but also another issues. And that's why I mentioned about China drama or movie, because they are now getting popular in Indonesia. I don't know, is there any connection between the joint statement with the high trend of Chinese movie or drama in Indonesia? I don't know. Yeah, there should be any research on that. Yeah, but talking about, yeah, joint statement with China, and also the phrase of overlapping claims. Yeah, it's so, yeah, I don't know how can, for me, I can imagine, because we make agreement between two parties, Indonesia and China. They are both non-English speaker, non-English country, and the diplomat from Indonesia and China meet and then create some agreement or some word in the text of the agreement. How can, I mean, when Farah mentioned about the hermeneutic, yeah, how can, what do you think, Farah? Do you have some talk about, there is an issue about the way the diplomat doing a negotiation? Because yeah, if now compare with, for example, agreement between Indonesia and US, yeah, US are, yeah, that's English speaking countries, yeah, and it is understandable if the content of agreement maybe put some advantage to the United States because of the language issue. But in with China, yeah, the situation is quite similar. Yeah, and the diploma, I think the capacity, the competency, I think quite similar, and the language also, uh, they use English. Yeah. But how can a kind of phrase like overlapping claims can be inserted? What do you think? This is like, yeah, just imagine ourselves when we doing like a negotiation, and then we try to. Is there any? Oh, Angel, yeah. While you may answer this question at the end, yeah. So because yeah, Angel already raised a question, I would like give a chance to her to start. Okay, Angelina.
Okay, thank you so much, Prof. Parkesit, for the opportunity. And I'm sorry to interrupt you before.
Oh,
So,
no,
I have a question. This is like a genuine curiosity of mine to Kak Farah. So, I've seen before that you use like three factors to determine how binding a treaty is, to use obligation, delegation, and precision, I think. And I have a question, well, two questions actually. The first one is, why do you choose obligation, delegation, and precision to measure this treaty specifically? And the second question is, do you think that we can use those three factors to measure any other international law treaties? Thank you so much.
Okay. Thank you, Angel. So I will move back to the, I guess, the legalization part. Okay. Okay. With regards to the first question on why did I use these three these three elements, is that because it is actually dimensions that form a legalization of an international document. So, sorry, am I still audible?
Yes. There was some lag, but it's going better. Oh, I think Farah is experiencing signal issue. Okay, just wait her to be back. Hopefully, it's not because again we reveal what China real intention. Maybe. Hopefully, there is no spy involved in this session. Farah, can you hear me?
Uh,
Okay.
Hello, am I audible?
Yeah, yeah. I will be back. Okay. You may turn off the video, maybe, Farah, to reduce the potential lag or troublesome. The potential lag or troublesome. Okay, it's like my voice is echoing in someone list.
Uh, Hello everyone, am I audible?
Yeah, yeah.
Okay. I'm joining on the other device, so sorry for the inconvenience. I will continue to answer the question by Angel. For the first question, on why did I use these three elements, obligation, delegation, and precision, in my analysis for the first question of research. So it's basically from the legalization concept itself. It's basically the legalization itself is consisting of these three dimensions, which may or may not be possessed in the international document. So, where did these three dimensions come? Is actually it comes from the practices of international law, international relations, where it is analyzed by how the state is using the language of an obligation in a provision of an international document, on how as both parties in an international document is delegating maybe a conflict that may be arising from the implementation of the document itself to a third party, as well as how precise is the provision is governed in a document. So it's basically came from the legalization concept itself, which is derived from the practices of international law, and it's still, I guess, it's still developing in the international law discourse. And for the second question, whether this theory or concept could be used in determining the binding force of the international document, I guess yes. However, as a specific note, for its transparency and objectivity of the analysis of the legalization concept, I suggest that the analysis itself for using the legalization concept is using a comparative study as well, because we need in positioning a document, we need to compare it to maybe two others documents so we can see clearly where the position is in the spectrum of hard and soft law. I hope it answered the question.
Yes, thank you so much, Kak Farah.
Okay, Farah, thank you again. Although maybe the final situation is not really supported, but that does not definitely discourage the quality of your answer. So don't worry about the technical issue. That's really common for online session. And no, again, I'd like to maybe the last. We have also Randy. Yeah, I think Randy also one of the talented student as well. Yeah, joined in Mukot in Washington DC as well, and I will give the chance to him to ask. Come on, Randy.
Thank you so
Oh,
much, Prof.
Jan
Parikesit.
and Jan Christopher. Okay, two
Okay,
more.
thank you
Two
so much,
last. Yeah.
Prof.
Okay.
Parikesit. Thank you. First of all, thank you to Kak Farah for the great presentation. I think this is a rising issue how the joint statement position in our diplomatic way. This is related to the first question. Actually, the question relating in the form of customary of international law. If I read the PCA permanent arbitration regarding this South China Sea, it's recognized that the unclosed provision is prohibited regarding the overlapping claims of the nine dash line. Also they mentioned in that particular document that they do not recognize the sea by the historical approach. And you've mentioned previously that this can create also the customary of international law. And the issue with this, I think the issue of this, it will be the creating the customary of international law, the recognition of a territory or the sea with by the historical approach. And I think with the issue currently, we can see also U.S. claiming that they have the right to Venezuela because the historical issue that Venezuela is America Latin. And so I think it's interesting how you will suggest Indonesia to make future affairs with other country, or how Indonesia position its in its foreign relation. What your suggestion to our president, Mr. President Prabowo Subianto, in that regard? Thank you so much, Kafara, for your great presentation.
Okay, thank you, Randy. And Farah, you may answer.
Okay, thank you so much, Randy. So regarding the solution, actually in my thesis I propose like two suggestions. I would say suggestions. The first one is to the international law academics or discourses. The second one is to the government of Indonesia specifically. For this issue, this specific issue, I guess I would say gratefully we have a simultaneously cooperation, a similar one with Vietnam. It is regarding, if I'm not mistaken, the either the exclusive economic zone or continental shelf cooperation in the delimitation. We are now in the process of ratification of the agreement between Indonesia and Vietnam to agree an area which is overlapping previously. However, since the agreement itself is already reached by the year of 2022, if I'm not mistaken, and we already have preparatory works, I would say, a naskah akademik in the House of Representatives of Indonesia, and I guess to negate the Indonesia's potential position, which is not aligned with the our long-standing stance, the ratification and the implementation of the agreement between Indonesia and Vietnam is the strongest one to negate the fact that Indonesia might be recognizing China's claim on the South China Sea. I guess that is the solution, and probably maybe I would like to connect it with Prof. Parikasit's question, whether how can we jump into the use of the overlapping.
Okay. Once we discuss about overlapping, then problem arise. I hope this just coincidence.
Am I audible, Prof. Parikasit?
Yeah.
Okay. So sorry again for the inconvenience. I will continue the answer. I guess I hope my previous answer is already heard with regards to the ratification and implementation of Indonesia-Vietnam agreement on the delimitation of their maritime boundary. And maybe connecting it to Professor Parikasit's question on how can we arrive into the use of the overlapping claims phrase in the joint statement. I actually confused too on the choice of words by the Indonesian government as well as the China government. However, it might be influenced by how the government's interest goes to, because I think this joint statement itself is covering a lot of issues, not only the maritime one, and as we have maybe may trace back to maybe President Prabowo Subianto's orientation on the development of Indonesian economic, it is quite maybe one of the factor of the effort for reaching the stability between the Indonesia and China bilateral relations. And by that saying, I would like to also propose a suggestion that Indonesia is quite a great country by history in especially in the realm of international law of the sea. I guess one of my lecturer, I guess Pak Mahartayasa, had told me in the class that Indonesia has a contribution to the formation of the United Nations Convention on the Law of the Sea, and I guess it is great for Indonesia to be consistent for implementing a UN clause, as well as maybe maximizing a way or a document or a mechanism that we can use which is aligned with United Nations Convention on the Law of the Sea. I guess that is my answer.
Okay. Thank you, Farah, for answering Randy question and my question as well. So because yeah, I think I don't want to be overly late on this evening, and I would like to invite one more because he already raised his hand, and I would like to invite Jan Christopher to start questioning.
First of all, Prof. Parikesit, Kak Farah, am I audible?
Yes, you are. Jan?
Okay. So to Kak Farah, this is merely a question of curiosity too, because previously I've read the ICJ judgment between Qatar and Bahrain in 1994, if I'm not mistaken. And within that judgment, the ICJ ruled that a joint communique or a joint statement could be, in a way, legally binding. Now, within the joint statement itself, it's also said that the joint statement will be, in a way, a basis for the Intergovernmental Joint Steering Committee to explore and advance relevant cooperation based on principles of mutual respect and so on and so forth. So my question is, if Kak Farah in the end founds that the joint statement is considered as non-binding as it is a soft law, could a non-binding soft law be the formal basis to establish the joint joint steering committee as per said within the joint statement itself, Kak? Thank
Okay.
Hey,
Uh,
you may answer, Farah.
okay. Thank you so much, Prof. Parikesit, as well as John. Um, yeah, the case that you have mentioned earlier is also one of my consideration in the analysis. So, it is quite familiar. And for the answer, I guess, in my opinion, for the formation of intergovernmental joint committee, uh, I won't say that it is a legal basis to form that joint committee. However, because I think structurally as well as systematically, the joint statement would be the United Nations Convention on the Law of the Sea itself, because it is one of the professional arrangement under UNCLOS to solve an overlapping claims problem between the parties to do a joint development, which may be supported by a joint committee, as said in the joint statement of China and Indonesia. However, I think, firstly, this joint statement could be a preliminary cooperation, I would say, preliminary agreement not as in like binding in law, however, an agreement between China and Indonesia for conducting a plan to form a joint committee to do joint development in the areas. And one of my concern maybe with related to the case of the ICJ that you have mentioned earlier is that not related to the joint development itself. However, there might be a potential situation where if only the South China Sea conflict is rising again, and one of the party of this joint statement could bring it to the ICJ and could strengthening its position as a recognition of Indonesia on the China's claim. I guess that's it. My answer.
Okay. Thank you so much, Farah, for answering all question. I think almost all question that you have answered correctly. And I know the time is not enough. Yeah, because the discussion is getting warm and getting intense. But again, because yeah, we have. I don't want to be or to spend more than 10 p.m. tonight. So uh, I can, yeah, I just want to inform you because now is in the Ramadan. Usually the event should start at around 7 p.m. usually, but because the Ramadan week, so and some people need to open the breakfasting, then yeah, we then decide that for the Ramadan week we will start at 8 p.m. But don't worry, yeah, I can confirm now that we will have another interesting session, not in the week, not within 3 days, but tomorrow. Yeah, I will inform to all the participants who are joining this event and maybe who haven't had any chance to raise a question tomorrow with the same time at 8 p.m. we will have also another discussion. Yeah, tomorrow the topic also interesting. Yeah, Carmelita Fondrawidaya. Yeah, will talk about redefining state responsibility for submarine communication cable destruction in modern warfare. Yeah, so submarine communication cable destruction. Yeah, what would happen if they destruct the submarine cable? There will be no UNCIL meeting because the internet cable will be break off. So this is going to be another interesting. Pondra also one of the talented student, and I will invite all the participants to join that meeting as well. And before closing this session, I would like to give two thumbs for Farah for the great and inspiring presentation, for Prof. Palguna, who are willing to join right until the end of this meeting, Ibu Dr. Dia, Bapak Dr. Made Budi Arsika, all the participants who are joining here, both in Denpasar, in Kuala Lumpur, in Zurich, and somewhere else across the globe. Thank you so much for making this event possible, yeah, and make some impact for the international law community. So thanks again, and see you tomorrow. And I will hand the event over to the Master of Ceremony. Thank you. The Master of Ceremony? Yeah.
Okay. Thank you, Ms. Farah Nadia, for that profound analysis, and Professor Parikesit for your expertise as the facilitator. Also to all participants for the stimulating discussion. It is clear that the intersection of political rhetoric and legal obligation remains a vital frontier in international law. We can also conclude that from today's discussion, the China-Indonesia Joint Statement is not merely a diplomatic document, but one with important legal and political implication. Although the statement appears soft in terms of legalization, its ambiguous phrases such as common understanding, joint development, and overlapping claims invite deeper interpretation. Through both legalization and hermeneutic analysis, we are all reminded that diplomatic language is never fully neutral, and that careful wording is crucial to protect Indonesia's maritime right and legal position. So before we proceed to the closing of today's session, we kindly ask all participants to fill out the final attendance link that will be shared in the chat box. Now, I would like to invite all participants to turn the cameras on as we begin the documentation session. Okay, the documentation session will be start in 1, 2, 3. Once more, 3, 2, 1. Thank you. Finally, I would like to thank everyone for their valuable contribution into this discussion. Please ensure you complete the attendance form to obtain the certificate. Let's take the insight we have again and keep engaging with the topic of today's discussion. On behalf of the organizing team, we thank you for your active participation. We look forward to seeing you at future event. Until next time, stay safe and stay connected. Om Santi Santi Om. Wassalamualaikum warahmatullahi wabarakatuh. Shalom, Namo Buddhaya. May peace be upon us.